So I think we're going to get going for the second day here. Thanks everybody for getting over the bottle of wine last night and doing more or less on time. So we're going to get going because we don't have too much time. We want to allow as much time as possible for some serious sessions. So I'd like to introduce, first of all, we're going to have Snjólaug Árnadóttir from the University of Edinburgh. We have Jean-Michel Marcoux from the University of Victoria, and Philippa Osim from Lancaster University. You have three papers. First one on maritime boundaries or sea, and two papers on essentially cooperation with some form of justice through human rights measures. So without any further ado, I'd say we kick off with Snjólaug. Thank you. Sorry, I'm going to give you 15 minutes. I do have, I did explain before, a yellow card thing. Basically means you have 2 minutes stuff. And then if you see this, it's not a good sign.
You can do small.
Okay. Good morning, everyone, and thank you for being here. I want to talk to you about how changing circumstances are affecting maritime boundaries. And when we talk about maritime boundaries, I mean both the process of establishing maritime boundaries, which is called maritime delimitation, and the validity of existing maritime boundaries. Geographical changes are creating a discrepancy between the maritime entitlements coastal states enjoy in surrounding waters and maritime boundaries. And this makes the boundaries inconsistent with the law of the sea convention. And this is essentially the crisis that I have in mind. And I want to determine whether existing international law offers any solutions to the problem. So a crash course in law of the sea, for those of you who are not familiar with this kind of field. So all coastal states enjoy exclusive sovereign rights in the waters and seabeds surrounding their land territory. And it is the land that generates the rights, which is derived from the basic, fundamental principle of law of the sea, which is that land dominates the sea. So from the coastline, you can see so we measure these entitlements from the coastline. It's a baseline there, so we identify either a line along the coastline or individual basic points, and from there we measure territorial sea, contiguous zone, exclusive economic zone, and continental shelf. And these are different regimes, different maritime zones. They are offered or afford different rights and obligations on the states, and they extend, the difference of how they extend from the coastline. But really the important thing to know for the purpose of this presentation is that all the rights are derived from the baseline and it follows the baseline. So when states unilaterally declare their limits, they move inwards if the coastline recedes, and similarly if it extends further up. But if there are overlapping claims, then states need to agree on boundaries. Then they cannot just go 200 nautical miles or whatever out. They establish either through agreements or judicial decisions. We have to have maritime boundaries. And boundaries, as they, like I said, agreements or judicial decisions, and they are established as fixed coordinates. So they cannot change, like the entitlements and maritime limits. So just as I wrote this quote, just as a shadow cannot exist without the object that creates it, maritime entitlements cannot endure when the land that generated them has disappeared. So if an island submerges, for example, the entitlements surrounding it also disappear. And that is the crisis, that the boundaries remain permanent. So the question that we're seeing here today is international law capable of dealing with the effect of calculated later changes? And I submit it is, and these are the two things that I think we could do in preparing for the crisis. So foreseeable changes to the coastal geography could be taken into account when we establish maritime boundaries. And the unforeseeable changes, which result from extreme weather events, for example, something that we cannot predict with any precision, they should, in exceptional cases, justify termination of maritime boundaries. This is a bit technical. Sorry. The equidistance method is the prevailing method of delimitation, and it's the only method that the Law of the Sea Convention refers to. So Article 15, so the United Nations Convention on the Law of the Sea from 1982 is governing law. And Article 15 that mentions the equidistance method, which is identifying base points, you see there A, B, C, D, and G, on both coasts, and then measuring the, finding a point midway between that is equally distant from both points. And this can be done for adjacent and opposite coastlines. And Article 15 says that unless there are special circumstances or historic title justifying derogation from this method, which use the equidistance line. It only deals with the territorial sea, which extends from what from the line. And Articles 74 and 83 deal with the exclusive economic zone and the continental shelf, and these provisions are practical and very really ambiguous, because all that they require is that states reach an agreement and achieve an equitable solution to the boundary disputes. So no method is given preference. But case law shows that all cases, really except for 3, have employed the equidistance line as a starting point, and then it's adjusted if special or relevant circumstances so required. And what I want to determine is whether foreseeable geographical changes are relevant, whether they can affect this line. So it's clear that coastal geography is the most important factor for delimitation. Because, like I said before, all the entitlements are generated by the coastline, and they do fluctuate to reflect changes in limits and entitlements. So coastal geography is what we use to establish an equidistance line, and also what we use to adjust it. But courts and tribunals have found that foreseeable changes are not part of this geographical changes that can be relevant. Most recently, in 2014, the Permanent Court of Arbitration declared that when choosing base points, it should only choose base points that are appropriate in reference to the time of the delimitation. And it actually explicitly rejected the idea of taking climate-related changes into account. Similarly, the ICJ found in the Black Sea case in 2009 that when choosing base points, it should only be due to the physical reality at the time of delimitation. But I actually think the Árnadóttir India decision, at least, they've been wrong, frankly. The Black Sea case did not mention capabilities at all. And the thing is, the knowledge that coastal geography is very unstable and bound to change in a matter of days, months, or years. It has been changing, that it is actually never really stable. I think that is part of the relevant geography. And in order to achieve an equitable solution, I think it will be more equitable in the long run to actually look to these changes. And there is one case that supports that idea, and that's the decision of the ICJ in Nicaragua 2007, where, as you can see there, the court found that continued accretion at the Cape might render any equidistance line so constructed today arbitrary and unreasonable in the near future. So, for that reason, the court decided to not even use equidistance as a preliminary step, but just draw a line at finding the general direction of both coastlines and midway between them. So just it's an approximation, and therefore, if coastal features are submerged or coastal recedes, this general direction will probably be the same for that in land. I actually, these are my proposals on how we could implement this, taking foreseeable geography into account. It's quite technical, not really want to do that. But like I said, as relevant circumstances, we can use it to just slightly adjust an equidistance line, like skipping base points that we know are hardly really, it depends on the day or something like that. And we can also abandon the equidistance line completely, like starting for us, and apply the improvised factor instead, or possibly even fluctuating boundaries, meaning that we just say the median line or something, and then that can change line limits. Okay, so this only can be done with foreseeable changes. I mean, we cannot be speculating when we establish boundaries. So anything that cannot be predicted with any precision, we cannot be taken into account. So when unforeseeable geographical changes occur, is there anything that can be done, or do we have to have these inequitable, unlawful, really, boundaries still permanent? There is a rule in the Vienna Convention of Law Treaties, Article 62. I assume most of you are familiar with it. Here, this is something that's a principle. And so it provides that unilateral termination or withdrawal from a treaty due to a fundamental unforeseeable change of circumstances is possible if it affects the essential basis of the treaty and it radically transforms obligations sustainably performed. I ask that you bear with me, just assuming that these requirements could be satisfied in exceptional cases. And to focus on the main predicament, which is that treaties established with boundaries are excluded. And my question now is, does that apply also to maritime boundaries? Are they just automatically excluded from not being terminated? The thing is that there is an important difference between land and maritime boundaries. And therefore, I think, so all commentators who have addressed this question basically just discard it by saying, well, boundary, maritime boundary, obviously excluded. But I think it's not that simple because, first of all, the fact that we call maritime boundaries boundaries, I don't think that in and on itself can just answer the question for us because it actually has been pointed out by scholars, and it's also clear from actually case law and boundary agreements that this is not the best phrase for maritime boundaries, that they are rather lines of allocation, lines of delimitation, or just limits, that they shouldn't be called boundaries. And so just the terminology is not enough, I think. In the ILC Travaux Probatoire, which is hundreds of pages, really extensive discussions on the exclusion of boundaries, they never ever mentioned maritime boundaries. There's no indication that they had in mind excluding maritime boundaries. And what's most important really is that there is an inherent difference between land and maritime boundaries. And the rationale behind excluding boundaries from the application of terms of substance was that boundary treaties belong to a special category of treaties that require stability. And obviously, land boundaries, they're completely arbitrary, and their main function really, or what's most important about boundaries, is that they remain in place and never move, not to jeopardize international peace and security. But maritime boundaries, maritime limits and entitlements, like I explained before, they are default, they are fluctuating. So stability is not primary requirement there. And the only clear obligation when establishing exclusive boundaries, right, is that they are equitable, not stable. So I don't think that rationale really applies. And also, definitions on what boundaries are talk about there being something that divides full sovereignty between states, and that's another thing. The states have rights and obligations, very specific in these water columns, but not full sovereignty. Only in the territorial sea we do have full sovereignty, but otherwise it's sovereign rights. Regrettably, the ICJ did address this question in 1976 when it founded the Eastern Continental Shelf case that continental shelf boundaries are excluded. The rationale was, I mean, they talked about the same applying, that we do need stability for these sort of boundaries, the same as land boundaries. But the fact of the matter is the continental shelf rights are very different from the other ones, because the continental shelf is just the land territory beneath the water column. So it has nothing to do with the ocean above. And so in that sense, it is, it is much closer to land boundaries. So my conclusion really is that territorial sea boundaries might be excluded as they deal with full sovereignty, and continental shelf boundaries possibly as well, because they are very different, because they're land territory, and they are the only limits that under the Law of the Sea Convention are afforded permanent stability. When I say that all limits fluctuate, that actually does not apply to convention. So they are very different. So I think still exclusive economic zone and contiguous zone boundaries could be subject to changes. So then, to conclude about, I think the foreseeable changes could be taken into account by establishing countries, and that unforeseeable changes could possibly affect the validity and lead to termination of at least exclusive economic or contiguous zone boundaries.
Thanks very much. So we're moving on to Jean-Michel. Jean-Michel is going to talk about how to avoid a crisis in the elaboration of business and human rights treaty, something that actually is very prominent in the international law at the moment.
Thank you very much. First of all, I'd like to take a few seconds my presentation in order to make sure I thank the organizing committee of this conference. So thank you very much, Ben and Patrick, for giving me the opportunity to present part of my PhD research here in Liverpool. It's truly appreciated. Now, as you can see from the title of my presentation, the future crisis to which my contribution relates concern most specifically the most recent attempt at developing a formal business and human rights treaty under the auspices of the United Nations. And more specifically, the roots of this future crisis can be located in two different resolutions that were adopted by the United Nations Human Rights Council in June 2014. First one is Resolution 26.9. And through this resolution, the Human Rights Council decided to establish an open-ended intergovernmental working group to elaborate a, quote, international legally binding instrument on business and human rights. This resolution was adopted through a recorded vote of 2014 with 13 abstentions. And most notably, among the states that positioned themselves against this resolution, we find key capital exporting states such as France, Germany, Japan, the United Kingdom, and the United States. By contrast, the second resolution, Resolution 2622, is a resolution to which the Council decided to further the implementation of the guiding principle on business and human rights. More specifically, this resolution was a means to extend the mandate of the working group responsible for the implementation of this informal instrument. The guiding principles are informal to the extent that they are not a formal treaty under international law. They were developed by a special representative of the Secretary General, Professor John Ruggie, and were fully unanimously endorsed by the Human Rights Council in June 2011. So, considering the opposition of key capital exporting states with respect to the establishment of a working group, of an intergovernmental working group to elaborate a formal treaty, combined with the efforts of other states to further the implementation of an informal instrument, I think it's fair to say that we're not close to the adoption of a formal business and human rights treaty, hence a potential crisis with respect to international human rights law. And given the importance of the guiding principles as an informal instrument in the discussions surrounding this formal treaty, I think it's worth looking a bit more closely at this instrument. And my goal in this presentation is to provide an interactional account of the guiding principles on business and human rights. And more specifically, the objective of my presentation is twofold. I'd like to first provide a more nuanced normative account of the guiding principles, despite their informal character under international law. And in order to do this, by doing this, I intend to assess whether or not it becomes a useful instrument that could be relevant to avoid a crisis with respect to the elaboration of business and human rights treaty. So ultimately, what I argue is that the guiding principles are currently a social norm that fails to produce a concrete sense of obligation. But with that being said, there are key aspects that distinguish the guiding principles from other informal instruments that were elaborated by intergovernmental organizations and that are related to the issue of business and human rights. So I'll first provide some details with respect to the interactional theory of international law, and I'll apply it to the guiding principles in order to see whether or not it can be a useful instrument with respect to future crises in this regard. So the interactional theory of international law is an analytical framework that was developed by two scholars, Jutta Grüne and Stephen Tu. Basically, what they posit is that international law exists by degrees, and that we can position each instrument on a continuum that varies from social norms to legal norms, regardless of their formal or informal character under international law. There's still a very singularity of international legal norms, that they are the sole international norms that will produce a sense of obligation. And this sense of obligation can be met when there are three requirements or three aspects that are found. First, international norms must be grounded in shared understandings between different international actors. Second, international norms must meet a set of 8 criteria of legality, and Grüne and Tu in this regard draw from the work of Lancaster in his book, The Morality of Law. Finally, the international legal norms must be applied and implemented according to a practice of legality. So more specifically, this means that the instrument must be, there must be a community of practice that emerges, and according to which observance of an international instrument is mandatory, despite its formal or informal character. So overall, this is an analytical framework that focuses more specifically on the content of an instrument, as well as different interactions between international actors involved in their implementation, as well as in their elaboration. Having said that, the second part of my presentation is to apply the interactional theory of international law to the guiding principles on business and human rights. Ultimately, what I'll conclude, as I mentioned in the introduction, is that it is a social norm, because it fails to produce a concrete sense of obligations. But there are some aspects that emerge from the application of the interactional theory, and that are worth mentioning because it distinguishes clearly the guiding principles from other informal instruments. I've conducted this interactional account by looking at the content of the guiding principles, as well as different statements and reports through a critical discourse analysis. I've also looked at, I've conducted 20 semi-structured interviews with individuals working for intergovernmental organizations that are involved in broader process of elaborating standards of conduct for private actors under international law. Ultimately, when we look at the first part of the interaction account with respect to the guiding principles, I think it must be emphasized that the guiding principles fail to reach any shared understandings with respect to the elaboration of a binding instrument. And this must be emphasized. We often think about the guiding principle as something that relies on strong consensus. It is true that several actors were involved in extensive consultation by the Special Representative of the Secretary General. And in this regard, when we look at the content of the guiding principle, there is some consensus with respect, for example, the use of the due diligence concept in the responsibility to respect human rights for a corporation. But when we look at discourses regarding the nature, the legal nature of the instrument, we see a clear divide between public interest NGOs and states on the one hand, and other states and representatives of the business sectors on the other. For example, there was a joint statement that was published by the International Organizations and Employer, the International Chamber of Commerce, and the Business and Industry Advisory Committee. Through this statement, these three organizations mentioned that they would support the guiding principles. They also stressed that, according to them, the guiding principles were, quote, not a scheme for attributing legal liability, or setting legal norms, and that the corporate responsibility to respect is a social expectation, but has no legal implications. So it's quite hard to suggest that there are shared understandings with respect to the legal nature of this instrument when we have this kind of discourse that underlies the elaboration. There's also an interviewee that summarized very well the divide that existed in the elaboration of the guiding principles. And according to him, quote, I think one of the contentious points, and I think it still exists to this day, has to do with the binding nature of the guiding principles. And this was more of an issue from the perspective of some NGOs who wanted a binding treaty that would directly impose binding legal obligations on businesses. Now, the second aspect of the interactional theory is a focus on the 8 criteria of legality. Basically, the idea in this interactional theory is that when an instrument meets these 8 criteria of legality, it appears as a legitimate instrument and could therefore create a stronger sense of obligation. This is conducted by looking at the content, mostly of the instrument. Now, I've added the 8 criteria of legality to the stream. I'm not going to go through all of them for this presentation, but there are some aspects I'd like to mention here. First, the guiding principles appear as a quite legitimate instrument. They meet 7 out of these 8 criteria of legality. The only that is problematic is the one with respect to congruence. So basically what is suggested in the interactional theory is that there must be congruence or some procedural devices to ensure congruence between rules and actions from the official. Now, the third pillar, the guiding principles, is a pillar that focuses on remedies, but there's no procedural device that would ensure that states would comply with their duty to protect human rights. With that being said, there is one key aspect that distinguishes the guiding principles from other informal instruments. And by other informal instruments, I think about the OECD guidelines for multinational enterprises, for example, as well as the ILO tripartite declaration for multinational enterprises and multinational enterprises and social policy. There is an inherent contradiction that exists in previous instruments to the extent that they acknowledge expressly that there's a need to address the lack of accountability of private actors under international law, but they also mention that the recommendations that we find in these previous instruments are actually recommendations whose observance is voluntary. Guiding principles are interesting to the extent that they avoid such an express contradiction within the instrument. So although it remains an informal instrument, nothing in the guiding principles expressly mentioned that it remains a voluntary instrument. Quite the contrary, actually. When you look at guiding principle number 11, it is mentioned that, quote, the responsibility to business and to respect human rights is a global standard of expected conduct for all business enterprises wherever they operate. It then continues by stating, business enterprises may undertake other commitments or activities to support and promote human rights, which may contribute to the enjoyment and support, and promote human rights, which may contribute, but this does not offset the failure to respect human rights throughout their operation. So overall, I think it's fair to suggest that the guiding principles appear as a quite legitimate instrument, although they fail to meet fully the criterion of congruence, but more specifically, it is an instrument that innovates to the extent that it avoids an inherent contradiction that we find in other previous instruments. Moving to the third part of the interactional account, I'd like to address the practice according to which the guiding principles are currently implemented. At this point, it would be inaccurate to suggest that this is a practice of legality. The discourses of different actors suggest that almost none of them perceive the guiding principles as something whose observance is mandatory and compulsory. For example, there are different national action plans that were elaborated by states through which they engage in the implementation of the guiding principles within their territory. When we look at, for example, the national action plan developed by Finland, it is mentioned that Finland considered transforming the due diligence concept into a legally binding instrument, but that this appeared to be something that would be impractical and quite difficult to envisage. The National Action Plan developed by the Netherlands refers to corporate responsibility to respect human rights as a social responsibility rather than a legal responsibility. So overall, it has been that the implementation of the guiding principles so far is something that is closer to a social norm than a legal norm. But with that being said, there are some innovations that have appeared since the implementation and the endorsement of the guiding principles in 2011. And more specifically, the working group whose mandate was extended through Resolution 2622 started in 2014 to use some communications and send them to states and businesses. And through this communication, the idea was to, quote, introduce the core concepts, obligations, responsibilities, and expectations set out in the guiding principles. So there is this practice that contributes to making the guiding principles a little bit more unavoidable for businesses and states that could be involved in adding violations of human rights. We're quite far from the practice of legality, but here we have an innovation that can move the social norms toward the realm of legality a little bit more. So overall, looking at the interactional account of the guiding principles, I think it explained that it remains the social norms. This mainly results from the absence of shared understanding with respect to the elaboration of a binding instrument from the very beginning, and also the absence of a complete practice of legality with respect to the way it is implemented. But with that being said, the guiding principles appear as an instrument that meets most of the criteria of legality, that appear as being highly legitimate, and that also avoid an inherent contradiction that we find in other previous informal instruments. And ultimately, the innovations like the one that we found from the working group with respect to the implementation of the guiding principles is quite promising in my opinion. So overall, my goal here is not to naively conclude the guiding principles will move toward the realm of legality and become an international legal norm despite its informal character. I think we have to be very careful when we do this kind of analysis, but what I want to stress is that the guiding principles are probably better positions than other informal instruments like the OECD guidelines or the ILHRU declaration. And ultimately, considering the guiding principles as a social norms has at least two implications for the elaboration of a business and human rights treaty. First, as a social norm, the guiding principles could shape different perceptions of different actors that are involved in the elaboration of the formal treaty. And it could ultimately shape stronger shared understanding on which the formal treaty could be anchored. Now, ultimately, although this might be a bit more of a far stretch, according to the Interactional theory of international law, it would be possible to see the guiding principles evolve toward a realm of legality and produce a sense of obligation as the practice evolves around it, and that could eventually be considered as an international legal norms. Now, overall, the idea here is that there's a need to depart from an approach to a formal treaty that is totally disconnected from the guiding principles. Once we recognize this social, the normative character of the guiding principles as a social norm, there's a need to include it in the analysis, and there's a need to include it in the elaboration of a formal business and human rights treaty. And I think that ultimately it does include some response for a potential future crisis with respect to business and human rights. So, thank you very much.
Thanks very much for that presentation. So we're moving on to a different angle, taking on the corporate impunity response to corporate impunity. So, thanks, Philippa.
First of all, I want to say thank you to everyone for being here, and thank you to the Organising Committee for having me here. My name is Philippa Osim. I'm a PhD candidate at Lancaster University, and I just led my PhD January this year, so this is my first year. I'm working on the accountability of multinational corporations for violation of human rights, with the Niger Delta region of Nigeria as my case study. My presentation today, I'm going to be leading the corporate impunity, developing international enforcement mechanisms with solutions to human rights violations. Now, this paper is a work in progress. I welcome your contribution and my presentation. So, starting off this presentation is a quote I lifted from the Hetty School of Governance working paper. Basically, what this quote states is that due to the state-based nature of international human rights instruments, agreements, international human rights agreements are entered into between states, and they place However, the continuous growth and power and influence of international corporations have actually questioned this state-based system of enforcement, especially as it relates to corporate activities of multinational corporations in developing states, which have poor governance structures. So, as a result, this paper is going to highlight the issues that are evident in this the current regulatory structures, and then go ahead to suggest how we can improve these enforcement structures. Now, in the 1970s, the issue of corporate violation of human rights was brought to the fore in the international arena. Multinational corporations complained that human rights should remain within the state, and it was exclusively the business of the state, while multinational corporations and private entities are concerned with the maximization of profits. However, through pressure from market-based consumer initiatives and NGO pressure, multinational corporations increasingly accepted or adopted codes of conduct that included human rights standards. These codes of conduct were actually used in their internal grievance mechanisms. However, there are problems with these corporate codes of conduct. Most of them are voluntary, so states and international corporations could opt on whether or not to adopt these codes of conduct. And in fact, the Business and Human Rights Resource Center is an international organization that monitors the worldwide operation of the codes of conduct in international corporations. Out of the 5,100 multinational corporations under its radar, only 300 of them explicitly adopt human rights provisions in their codes of conduct. And one of the reasons for this is because there's some multinational corporations that do not see the need to adopt this human rights codes of conduct. For example, we have the multinational corporations in the extractive industry that do not deal directly with the consumer. So there's no reputational incentive for them to actually want to adopt this human rights provisions in their codes of conduct. There's also an absence of systematic reporting to see that these multinational corporations actually abide by the rules of standards that they have adopted in their codes of conduct. And there's also no legal system for enforcing whatever remedies or whatever decisions that are made in their internal grievance mechanisms. So individuals are left to seek redress in the home state, in the host states of the corporation. The host states are the states where the multinational corporations actually perform their activities. However, these home states and regulatory measures are not without their shortcomings. Because multinational corporations operate in developing states, and these developing states most of the time depend on the multinational corporations for their resources. For example, Nigeria, which is the home of the Oniversity, that is the case study for my presentation today, depends on petroleum resources as the mainstay of its economy. So it tends to provide an environment, an enabling environment for multinational corporations, so as not to use vital foreign direct investment. So there's some instances where even if these states actually are willing to regulate these corporations, they might not have the technical capability or the financial resources to actually undertake complex investigations that involve that are in the business and human rights sector. So they are left to seek redress. And another forum, which is the home states. The home states are the countries of origin of the multinational corporations. And they have also been attempts by the reason why individuals seek home states is because home states are known to have higher standards of human rights. They are also known to be more technologically advanced and have more resources to be able to tackle the complex investigations that are needed in business and human rights issues. So there are some home states that have tried and made attempts to actually produce legislations that will regulate the activities of their multinational corporations in other states. In America, in Australia, the United Kingdom, and Canada, they've all tried to bring up legislation for this purpose, but they have not been able to pass them into law. They have all failed. But there was one particular domestic legislation that actually recorded some substance, the United States Alien Tort Claims Act. But that too has also had its own difficulties. The issue of foreign non-convenience, separate legal personality of the corporations, the insurmountable cost for plaintiffs in a different country where the violation actually happened, the cost of transporting witnesses, the difficult investigating those issues impede the effect of the United States Alien Tort Claims Act. So because of that, the international community tried to look for ways in supplementing these lapses. Some of the initiatives have been the OECD guidelines, the ILHRU tripartite declaration, the United Nations Global Compact. Now, these international initiatives have provided principles and standards. However, they are all voluntary, mirroring the detrimental effect of the previous regulation attempts. They are all voluntary, and there is no international body, or there is no independent body that actually enforces the principles and standards of these international initiatives. However, in 2003, there was a proposal of the draft norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights. Now, this took a different step from the previous international initiatives. It sought to produce binding obligations for multinational corporations. However, this draft proposal was rejected by the United Nations because multinational corporations heavily opposed it. So the United Nations thought that it was too premature at that time to bring up binding obligations on multinational corporations. The Secretary General of the United Nations has now appointed a special rapporteur to look into the specific obligations of states and of multinational corporations. And the special rapporteur came up with the guiding principles. And the guiding principles is seen as a more comprehensive list of principles and standards, and it's more widely recognized by states and by multinational corporations. But it still suffers from the issues that had been reflected in the previous regulatory mechanisms. That is because it still relies on states for its enforcement without dealing with the underlying problems of state regulation. So, from the totality of this, I have found that the major problem in the human rights legal regime is rooted in the difficulty of reducing the ideal of good governance to a set of clearly defined binding rules that can be interpreted and enforced by trusted institutions that are easily accessible to individuals. So what I have decided, or what I thought would be the best way to do this, is to agree on a set of universally accepted norms, address the corporations, clarify states' duty to protect, produce an effective enforcement system where those affected by the abuse have safe and affordable access. The enforcement system must be independent from state and MNC influence. It should reflect the interests of all actors in the business and human rights regime. And I think the international community has already put something that kind of mirrors my suggestions in the works. That is the open-ended intergovernmental working group on business and human rights. The future treaty, if it actually comes into being, is going to set a standard, a universal standard, where direct obligations will be attributed to multinational corporations and probably clarify states' duties to protect. Now, how do we enforce this future treaty, if at all it comes into being. And I think, or what I suggested, or my suggestion is that we can make use of the current grievance mechanisms that we have in place. First, we can start with the internal grievance mechanisms like multinational corporations. We can modify this by placing them against the general provisions of the future treaty, because this, starting this way will make it more accessible to victims and individuals or communities who have had their human rights abused. It saves costs, it's easily accessible, and uncomplicated. Now, there should also be a provision in the treaty that provides that where the victims are not satisfied by the forms of redress that they have received from the internal grievance mechanism, they can seek state regulatory mechanisms who will review the decisions of the multinational corporations. Now, these state regulatory mechanisms will be subject to the be guided by the provisions of the international treaty. Now, where the international treaty or where the state mechanisms have not adequately addressed the issues brought by the victims, or where the victims are dissatisfied, I have thought that they should look to the working group of the Committee of the Human Rights Council. When the United Nations norms on business and human rights were rejected, they actually proposed that the Subcommission of Human Rights there would be the body that will establish the working group. The Subcommission of Protection of Human Rights suggested or considered establishing a working group to implement and enforce the human rights obligations of the multinational corporations. But because the United Nations saw the UN norms then as a premature step, it cancelled the whole process. But because its attention has now been brought to the fact that we need an international enforcement or international binding treaty on multinational corporations, I think it's time that we now reawaken the idea that was put away in 2003. So the perfect way of doing that is to use the working group of the Committee of the Human Rights Council to do this, because it will avoid the issue of the lack of political will by states on multinational corporations. It's independent of states, independent of multinational corporations, and the working group is already in the process of formulating rules and principles of international obligations for multinational corporations and states in the area of business and human rights. So there will be, the right body to be able to look into, to review decisions from multinational corporations and from state regulatory mechanisms. So this is a diagram of how I want the regulatory mechanisms to be from the multinational corporations, international grievance mechanisms, the state regulatory and enforcement mechanisms, to the intergovernmental working group. So in my conclusion, I'll say international human rights, so human rights are rights that are inherent to the individual. So attention should be placed on finding mechanisms that will better ensure the protection and enforcement of the human rights of the individuals.
Thank you. Very much for all of you to keep to the time, and so we do have a bit of time. I'm just looking to organize how we can technically go over at least 10 minutes as well. 15. Okay, cool. So we have 15 minutes of time for discussion. So I open the floor up. Yes, well, we're going to take maybe 3 questions at a time. Same way as we've done yesterday. So please go ahead.
My question is for Philippa and Jean. I don't know if you have considered the problem of enforcement and enforcing international obligations. And for Jean, if you are proposing a new international treaty that will take cognizance of what is already covered in the UNTP. Have you thought of what happened to the UN, why it was not affected? Because rightly said, there is the powerful states, the economically powerful states, like the US, Britain, Germany, these are what they call it, and those that are mostly opposed to it. The developing world embraced it. Because these powerful states opposed it, it was never adopted. So I did consider how we can further develop the UNGP that we adopted in view of the fact that we are not tended to do that. It was not. And for Philippa, I've looked at your enforcement procedure for your proposal. My problem is, looking at moving up to state regulatory and enforcement mechanisms, I don't know the mechanisms at the state level that will enforce what you propose. I don't know if you have taken into consideration the weaknesses in enforcement institutions in the developing markets. But if you take that into consideration, then it will be difficult to find that states, especially those when we talk about human rights violations, we're not talking about the Western countries. There's nothing like, not very much like that, like what happens in Niger Delta. So who is going to enforce it? Are we going to rely on the same cost?
I think we're trying to get to the end of the question.
Okay. Yeah, the question is, because at the level of enforcement at state level is a problem. Enforcement at international level is also a problem. Who will enforce the order that is made at the international level?
Thanks. Okay, so that's good.
Should I jump on the question from Anna? Thank you very much for your presentation. I'm really interested. I suppose the two things that we bring two papers together is that they concentrate on whether the existing instruments should be binding or whether the new treaty should be established, who should enforce existing instruments. And I find your use of interaction very particularly compelling. Jean-Michel, I suppose my question would be to take a step back from me and think more broadly, a very simple question of why. If you understand the international law tradition, subject to international law, what is it about international society or the changing nature of business practices that would make such a fundamental change in international law necessary and urgent?
I have a question for our first speaker. You made a big distinction between foreseeable and unforeseeable changes and implementation. Could you elaborate a bit on what exactly makes the difference between something that is foreseeable and not how foreseeable it needs to be? Do we have to know the consequences in detail? How do you make that quite important distinction in the presentation with actual concrete?
Great. So can we move from my left to right to Philippa? Would you like to go first?
Okay. So your question was who will enforce the order of at the international level, the state and international level. Now, when I was talking about the enforcement method, I first referred to the differences in the state enforcement, the differences in their regulations, and the regulations and the legislation. So what I proposed was that the international treaty should have a universal standard that would be applicable to the states. So all corporate MNC procedures, or all human rights legislation that are related to transnational corporations should be measured against the international standard and be enforced by the states' enforcement mechanisms are already in place. You have the judicial and the judicial enforcement mechanisms in place in the states. So when it's measured against that standard, which you use the already established enforcement mechanisms, where there's not a satisfaction of those enforcement mechanisms, there should now be an appeal to the international bodies and working with national working group who will review, the decision of the states, and then see how we can make provisional pronouncements on the multinational corporations, maybe through laying of fines, or to come up with something way of enforcing international procedures.
Yeah, if you look at it, okay.
Thanks for your questions. I'm well aware that the United Nations norms failed to become under ILHRU of power. This is something that comes across clearly from different discourses from international enterprises, yes, and several exporting states, where I do think that there's a game changer is really the absence of an express voluntary character. I think it's very important to distinguish the informal character, which is not the formal treaty or international law, but the fact that the guiding principles were established as something that cannot be easily avoided is very important. In my PhD research, I've analyzed like 9 different instruments, and when I compare the practice of the OECD guidelines for national enterprises with the guiding principles, it's 2 different worlds. The OECD guidelines is often implemented with discourses of corporations saying, well, it's mentioned, it's voluntary, so who cares? That's basically that. You cannot say that with the guiding principles. They can say this is not as legally binding as you would like it to be, but they have to struggle a little bit more, and it makes it harder to avoid and circumvent the guiding principles. So I do think that as a social norm, it has changed. It can change the dynamic between different actors, and we do have to see. I mean, it's a social norm, so it can change the behavior of different actors, but you have to grant some time in this regard. If I can just add in a little aspect regarding enforcement, I think that there's a very good model with respect to the OECD Anti-Bribery Convention, to the extent that states agree to establish the liability of legal persons within their own legislation for their conduct elsewhere, abroad. And after, there's a peer review mechanism where other states assess whether or not the activities of the states are sufficient in this regard. There's still a lot of corruption, but you have this mechanism, enforcement mechanism, that is probably more compelling and more useful than what we would get in other instances. And with respect to the treaty, why would we need a treaty? It's a good question. I think that there's a clear lack of accountability. So far, what we have are these informal instruments. Mostly in corruption, it's different. We do have some binding formal instrument. But with that being said, there's a line from John Ruggie who said why we need these kind of norms. Well, basically for the same reason why the different corporations ask for protection for their investment. They don't rely on the host state. They don't trust the host state to have protections for their investment. So why should we rely on the host state and think that it should be sufficient with respect to accountability? So it's a bit of the same mechanic that operates as saying, well, if we granted protections to international law, why not accountability to international law? So there's this dynamic, and I think that it has been something that was put forward. In my opinion, it's quite convincing. Not saying that it's not appropriate what is done at the host state, but there are relations of power that sometimes make it harder to implement the legislation that are there. So, yeah, sorts of questions.
Yeah. Thank you for your question. So about the distinction between foreseeable and non-foreseeable changes. Maybe like a technical example would be foreseeable, something like gradual sea level rise, something that the International Panel on Climate Change predicts like quite with precision. And then unforeseeable could be something like an extreme weather event or hurricane. Or I actually also in my PhD thesis I'm dealing with changes that are not climate related, like the new volcanic island coming up, something like that. That's purely something that we cannot predict. But then there will be degrees of foreseeability. So, like sea level rise, probably we can with some accuracy say that a rock that generates some impediments is just about to go under, and it's clear within a couple years. But then, and then the methods I didn't go into really how some methods would require less precision information because the ability to filtering models could just go with whatever changes occur. So if we know that changes are imminent, or not, don't know exactly what. So, but in how I actually identify all this and incorporate it into my research, it's actually just really started thinking about how I'm going to really, the science side of it. And it was just last Friday I first met lecture in climate change next to that, into basically incorporating IPCC data. So I'm not sure exactly how we'll do that in practice, but that's the idea of that.
I'm allowed to come this way. My presentation is on USB.
So I have a question. What's the what have you analysed anything from the states like the Maldives and places like that? I mean, this is obviously climate change related and sea level and stuff. Have they been a particularly loud voice in terms of the needs to address this potential problem on costs and in the rural community? Have you looked into that yet, or if you have, what are they saying?
Thanks.
Thank you very much. I have to read most of the papers, and I have a lot to see questions, but I know nothing I'd love to see. So, purely from a newspaper perspective, I'm just going to be in Canada, and there's lots of discussion around sort of the Arctic at the moment, particularly the US is sort of one side and what's going to happen. So, it foresees that the Arctic is not really going to be quite lucrative for them, I think. So, I just wondered if you could speak a little bit about it. The US, as I understand, is not has a maritime law to see. So I think the debate is let's ratify the law to see because I think they see it quite beneficial to sort of harnessing some of the lucrative potential of the maritime project. So I wondered whether you could just comment on how the US is going to play out and how the Arctic will play out in which it is very foreseeable, I suppose. And maybe just a sense of politics around the use of the sort of law to see in that sense. And for the other guys, just a very general question. It always strikes me we have a teacher conference Friday. We talked a lot about the sort of responsibility, lack of accountability of corporations. One thing that we didn't focus enough on, I think, is the extent of corporate involvement in governance at the domestic level. So the corporate lobby on the domestic state. So I just wondered whether you could comment on how really important it is to think domestically about control of corporations as opposed to an international framework, which an international framework is all well and good if domestic states have any intention of minimum subsidies they're disempowered by the corporate lobby.
Thank you. I'd say maybe a couple of minutes, so 3 minutes if you want to give you two, and you had a few questions.
Okay. Yeah. Thank you, and thank you both for your questions. In regards to Maldives and these submerging island states, they haven't really. I mean, this hasn't actually been discussed much. Surprisingly, except for the scholars who have commented on this are all talking about how we can implement moves or somehow ensure stability, which is the opposite of what I'm saying. And obviously, submerging states want that. They don't want to, as they lose land territory, to also then have to draw back their patterns. Because if only land is submerging, then that would mean that the maritime zones just grow bigger and bigger and bigger, as much bigger as that disappears. But that would be inconsistent with the long sequence, which has ongoing applications. So mean, their view would clearly be that they want stability, but then there are really interesting questions related to that in my mind, like visitors to the Maldives who have been buying up land in India, so basically preparing for the whole territory to go under. And then if we would have stable limits, would they then still own the ocean? But, you know, a nation without land owning massive measures is way more than allowed under Lot C. So, yeah, that would be the reviews that they want. And in relation to the Arctic, I actually, being from Iceland, it should be better informed than that. Yeah, Iceland has a claim. For example, all the Arctic states, all states that have access to there do have claims. And the US, that's true, they haven't ratified the convention, but at least all of these provisions that I'm dealing with, and the US has actually declared that they view all of this to be customary international law, so binding upon them whether or not they pass it through the Senate. And well, since it's ice anyway, what is, you know, melting there, that is water column anyway, which it doesn't, then it won't affect the actual boundaries unless where the ice causes sea level rise. And states only where beyond the boundaries from states surrounding the Arctic will there be high seas, and that's where the US and all states of the world will have claim. I mean, this obviously will have different effects for different states. Like Iceland isn't actually probably going to be submerged, it's rising at places because of the weight of the glacier going off, and actually not actually rising. So boundaries not being as stable or not reflecting the change could then, for example, then our claims to the Arctic interaction would not be affected at all, or less. I'm not sure. Answer.
I guess the thing the US is want to exploit hydrogen. I guess that's what I'm getting at. Perhaps we would be extending we could predict use the law of sea measures. Sea territory. Just that, well, at least Canadians.
If the claims of other states are proceeding on that level of more expenses.
Yeah.
Well, yeah, that would make sense. Thank you.
So I think we've gone to the question on lobbying. So, is that anything to add there?
The question was why don't we focus on the state-based mechanisms of the international? We can find international alternatives.
Maybe not so directly, but do you think it's important to take into account state level?
Yes, and corporations, international corporations are creatures of everything. So yes, it's, you know, the first point of call would be the states for the regulation of transnational corporations' activities. But we can see that, you know, these state-based mechanisms are inherent to the threat. For example, like a country like Nigeria, where they depend solely on petroleum products that are produced by foreign multinational corporations. They have to create an enabling environment for multinational corporations to stay. Because if they don't do this, they might also move to other countries and house continue their production elsewhere. So in order to keep them in their countries and ensure that the production process continues, improves the economic situation, they have to provide conducive environment.
I'll just add something very briefly. I agree that this study must be expected, and there's like big issues that could be, but I'm a little bit more involving the state in this regard to make like the Elaboration convention and corruption. because I think that there's probably more that can be done in this regard. Of course, there's going to be lobbying in position, but I think it's a little bit more manageable at the state level than at the international level. Extraterritoriality is still a big issue, so I think that we need to go through international law in order to go to this. But I think that imposing the responsibilities to corporations indirectly through states is probably better than just directly under international law. So I would support the idea of going more through states than without states.
Thanks very much. I think we should probably conclude. I would just sort of add on the issue of lobbying. There is a possibility under the treaty. There's some people talking about concretizing check obligations to states under the treaty. That would be one issue that could be legalized under the treaty. Campaign contributions, for example, could become regulated under the treaty. So that would be one aspect. But I'd like to thank everyone for their great presentations and great answers.